Give me that thumbs up if you can hear me. If you don't want to, I'll go. See if I can hear myself. If you don't want to, I'll go. Yeah, I can. What's good with it? What's good with it? What's good with it? It is Friday. I said I would peep in for a minute on my regular scheduled day. See what y'all was doing. What's good? Hey y'all, so let me do the chat call. What's good with it, Sonya? You was first. Woo! Woo! Red Bunny, what's good, lady? Hey, Regina White. Hey, Sweet Bay. Hey, honey. Hey, Cool BJ. Yes. So make sure y'all be a darling and hit that like button. Please. It is free. Like button. Hit the like button if you love yourself. Hit the like button if you hate my ass. Hit the like button if you're glad you are here to hate my ass. Just hit the damn like button. That's all that's required. It's just one little boop of the like button. Y'all got anything going on today? So, let me see. Do I have anything to start out with in the intro? Let me see. Ain't really nothing to talk about. All is well. No, I ain't going nowhere. Somebody, yeah, I still get messages. You leave it? No, honey. I am not. I'm just not gonna be here all, a whole lot because my dumb ass decided to take my ass. Oh Jesus, I can't even describe it. Start back working outside the damn house a little bit. I don't know why I did that. I've been snoring and complaining ever since. But anyway, so let me get down to the nitty gritty. So I saw where our favorite Mary Judge, Milton's Brown attorney, and at this point, how this lady gets down, we shouldn't be referring to her as a defender, right? They have public for the state, federal for the government, right? We need to call her a lawyer because that's really what she is, right? But she decided to do some work at a discount price. So shouts out to her for that. Now remember, so I just want to give y'all a refresher. We went over the confrontation clause, hearsay, severance, Crawford, Bruton. We went over those things because those are normally the things that you will see in a case where there is conspiracy, you got co-conspirators, co-defendants, and all of that. You'll see a bunch of objections and things like that going forth in the pre-trial, right? This is standard, okay? So a lot of stuff goes on. Of course, it gets extra when you have co-defendants. So, what I am going to do, let me pop up the document. I don't know why I seem so tired. I don't know. Now, see, when it comes to anything dealing with Santiago, I can take my time and get to it. Because I know, oh, honey, it may be butchered. Let me put it up there. Let me see if I can increase the size. Okay. And let me make it full screen. So what I'm doing now, if I can find it, we are reading it, breaking it down, and analyzing it. Honey, I had to change the damn name to RBA. Reading, breaking down, and analyzing. Okay. So right here, you see it's Milton Brown's response to government Santiago Proffer and motion to admit evidence pursuant to Federal Rules of Evidence 801 D2E. All right. Okay. It says Defendant Milton Brown by the Federal Defendant Program and its attorney, Mary H. Judge, respectfully submits this response to the government Santiago Proffer and motion to admit evidence pursuant to Federal Rules of Evidence 801 D2E, docket number 231. Argument. This response proceeds in two parts. First, Mr. Brown demonstrates the insufficiency of the government's Santiago Proffer with respect to its lack of detail and specificity. Second, Mr. Brown explains how the government's insufficient Santiago Proffer unduly burdens counsel as it pertains to the drafting of limiting instructions. Okay, so limiting instructions. I don't know. I ain't gonna say that. But let me tell you what limiting instruction is, because I've heard it been defined as a bunch of things. Limiting instructions is pretty much the judge is telling the jury to consider a particular piece of evidence for something particular and nothing else, just something in particular, right? So that's what that means. It doesn't mean there's a limit on something. The judge need to put a limit on Mr. Brown. None of that. It's talking about limiting what the evidence can be used to prove, right? So that's what they're talking about. They just want to make sure that the evidence is used to prove a certain thing. Okay. Okay, so I guess right here she says that Mr. Brown explains how the government's insufficient Santiago Proffer unduly burdens the council as it pertains to drafting of the limiting instructions. So I guess she's saying that due to all of the asks that the government did in the Santiago Proffer that we went over, she's saying that it is causing an issue with drafting of her limiting instructions. I guess she has for the judge to instruct the jury to is when it comes to considering on a piece of evidence. Okay. It says the government Santiago Proffer lacked the necessary specificity. Shit. The government did not identify which specific statements it seeks to admit under Federal Rules of Evidence 801 D2E. When seeking to admit co-conspirator statements pursuant to Rule 801 D2E, a party must prove by a preponderance of the evidence that 1, a conspiracy existed, 2, the defendant and the declarant were members of the same conspiracy, the statements were made during the course and in furtherance of the conspiracy, and it's case law, a whole bunch of it. Okay. It says in the United States, the Seventh Circuit of 2003, the Seventh Circuit offered a brief explanation of the function served by Santiago proffers. Under Santiago, a district judge may decide before trial to admit co-conspirator testimony based on the government's proffer that it has sufficient evidence to prove the existence of a conspiracy by a preponderance of the evidence at trial. This procedure helps streamline trials by permitting the government to introduce co-conspirator testimony at any point during the trial rather than waiting until after it has provided sufficient independent proof of conspiracy. Okay. It says rather than provide the actual statements that it hopes to admit, the government instead gestured at three broad categories of statements. Those categories are excerpted here as follows. Number one, statements made by individual A, B, C, D to each other, to others, or in documents in the course of collecting and returning to defendants videotapes depicting Kelly engaged in sexual acts with minors. These statements include, for example, those related to booking travel and making arrangements to meet with defendants for the purpose of returning the videotapes. Number two, statements made by individual A, B, C, and D to each other, to others, or in documents regarding payments received or owed to collect and return to defendants videotapes depicting Kelly engaged in sexual acts with minors or to ensure that they would not cooperate with law enforcement or otherwise disclose information regarding such activity. Number three, statements made by individual A, B, C, and D to each other, others, or in documents regarding polygraph examinations administered concerning individual B, C, and D's knowledge of or efforts to collect and return to defendants videotapes depicting Kelly engaged in sexual acts with minors. As described by the government, these categories lump multiple declarants together and only vaguely refer to the possible contents of their declarations. As a result, the proffer also lacked the following information for any particular declaration. Number one, the given declarant's identity. Number two, the time or date of the declaration. Number three, the location of the declaration. Number four, the context of the declaration. According to the government, this enacts categorical approach was necessary because the statements are too voluminous to be listed in their entirety in this proffer. There is, however, no support or precedent offered for that claim in the government's proffer. The government does not provide a tally, word count, or any other measure of the statement's supposed volume. On the other hand, drawing from undersigned's review of discovery, counsel believe it would be practical and reasonable to identify and provide the actual statements verbatim, paraphrase, or summarize. As evidence of that practicability, consider the fact that the government prepared written grand jury statements for individual B, C, and D that total only a few dozen pages in length. Additionally, the government surely must have the desired statements prepared and organized at this point in the trial preparation progress. Oh, okay. She's trying to force some kind of statements out of them. Moreover, in its act, the categorical approach offered by the government is extraordinarily and inappropriate insofar as it frustrates any attempt to apply rules 104A and 801D2E. Okay. To start, The text of Rule 801D2 states that the statements must be considered. Federal Rules of Evidence 801D2. Okay, why did she cut off like that? Well, let me start over. To start, the text of Rule 801D2 states that the statement must be considered. Federal Rules of Evidence 801D2. Further, that necessity becomes apparent when one attempts to apply the rules. After all, when applying those rules, court must make a preliminary determination as to, inter alia, meaning among all things, whether under Rule 801D2E, the declaration was made during the course and in furtherance of conspiracy. Okay. So when I think the last two times I talked about this, I talked about the co-conspirators hearsay, how that works. Along with that, if that is admitted, then it has to be also proved. The conspiracy also has to be proved outside of that with another piece of evidence, right? So here, let me see. Here they are talking about Borgerly, right? And the Borgerly rule is if that's a statement made by the conspirator that is offered against the other party, like maybe R. Kelly or what have you. And when it's determining the admissibility, it's not bound by the rules of evidence. So it doesn't violate the confrontation clause, right? So she may at some point, I don't know if it be in here and I can't remember prior, but she may at some point say they start making an argument that all of this, what the government is asking for in the Santiago Proffer will violate her client's right to confront, right, which is the confrontation clause. So all of this gets confusing because there's so much going on. You got three different people, three different defendants. You have so much going on as far as this paperwork. You have apparently statements, right? If they are found to be non-hearsay, then they are admissible. Or if they are found to be hearsay, it may be that's going to be admissible if it's offered to prove the truth of a statement, or if it's found to be hearsay with an exception, that's also admissible. So, but I went over that several lives ago. So let's see. Okay, so how, under the government's approach, is the court to make those determinations? Okay. How is counsel to respond and object without the statements themselves? Oh, okay. The dates the statements were made and the context of the statements. The court and the parties are severely limited in their ability to evaluate the statements. Ultimately, given these limitations, an amended Santiago Proffer is necessary before the court can rule on the government's motion. Okay, so she's asking the government to resubmit their Santiago Proffer, but also address her concerns, which is the questions I just read off. So this is a pretty good motion, because you know why? We have remedies, right? We have remedies in here. So this is what she's asking for. It says, B, the government did not specify which statement went to which conspiracy. To reiterate, the government has the burden, by a preponderance of the evidence, to establish three requirements when seeking to admit co-conspirator statements under Rule 801D2E. 1, a conspiracy existed. 2, the defendant and the declarant were members of the same conspiracy. The statements were made during the course and in furtherance of the conspiracy. Case law. The third requirement is discussed above. Here, Mr. Brown's response concerns the second requirement. The defendant and the declarant were members of the same conspiracy. Okay, let's see what she says. That requirement is particularly relevant here because, as alleged in the indictment and argued in the government's motion, this case involved two conspiracies. Oh, okay. One, the obstruction of the justice conspiracy, meaning they interfered with the investigation. And when I say interfered, maybe like lied or didn't give information or things of that nature, right? So that's the obstruction of justice conspiracy. And then number two is the receipt of child pornography conspiracy, meaning that's the conspiracy where they were whatever went on with getting those tapes and all that type of shit. That's what they're talking about there. It says, in addition to its failure to provide and identify the specific statements it seeks to admit, the government also failed to specify which statements go against which conspiracy. All that the government provided were the three categories of statements listed in Part 3 of its motion. As provided, those categories are not sorted by conspiracy. It is not manifestly clear which statements go to which conspiracy. That information is necessary because statements of one conspiracy may not necessarily be admitted against another conspiracy. You got case law. And it says in Utah, December 21st, 2021, holding that the communications between the Poncho conspiracy and the Gordo conspiracy cannot be admitted against each other under Rule 801D2E because the evidence did not support a finding of one large conspiracy. Oh, okay. So what she's saying is it has to be separated. The evidence has to be per conspiracy because if submitting it as she says it is now, how the government is, it's not evidence of one large conspiracy is what she's trying to say with this. So, and that makes sense. She has a good argument with that. Because when you're dealing with this hearsay situation that's going on, you got the confrontation clause that's out there because the co-defendants might not testify. Therefore, somebody, who's ever, who's like, I'm gonna use R. Kelly to be exact, to be clear, right? If Milton Brown and what's his name, Darren McDavid, don't testify, then you got these statements and that's in that, maybe hearsay. And if it's hearsay, that means no one's there to motherfucking to cross-examine to make sure that the statements are actual and factual. So she has a good argument. And when with these statements that she's talking about, it has to be to each conspiracy because she pointed out that there were two. I can't remember the indictment. All I remember is this conspiracy that's dealing with the tapes. I didn't know. I forgot about the obstruction of justice. Exactly what was that? The actual elements with regards to that, I'm not sure. So I hope I ain't confuse y'all, because she makes it plain in this. It says the government Santiago Proffer does not allow. Oh, wait a minute. Did I jump? I jumped. I'm sorry, y'all. I'm all over the damn place. Hold on. Okay. Okay. Here's a case law, and it says to a Ford conspiracy case in holding that certain statements could not be admitted against certain conspiracies. the government must be required to identify which statements go against which conspiracy. This is particularly true in Mr. Brown's case, as he is charged in count 6 only. Oh, she's doing a good job. That makes absolute sense. She needs to know which one of these statements and this evidence goes to Mr. Brown, count 6. Because if the government is just introducing these statements and this evidence, you know, and I guess she's trying to say is like if when the government lays out their case and admit the evidence in, it may confuse the jury as to what evidence is supposed to be considered per conspiracy. So she has a good argument. But I do see that there could be a remedy to that when the prosecution responds. So I don't think that's a big deal, but I do believe, I may be wrong, but I do believe the judge will, enforce this because one, it just makes sense. Unless the government has um somehow has it where they have tied all, tied the conspiracies together. It could be a situation where it was one conspiracy, something happened in furtherance of the other. So I don't know how the government is going to lay their case out, and we don't know what all they have. You know what I'm saying? So that's kind of hard to decipher right now. But she makes a good point. Also, you can also see that she is trying to make sure that only the evidence that's dealing with Mr. Brown is presented. You know what I'm saying? So probably somewhere as we go on, they probably may bring up the severance again or what have you, but we'll see. Or some type of remedy for that. Okay, as discussed above, it says the government, Santiago Proffer, does not allow opposing counsel the opportunity to draft necessary limiting instructions. And I told you what limiting instructions are. Limiting instructions is just instructing the jury to only consider a certain piece of evidence for a certain thing and nothing else. Don't use that evidence to prove nothing else but a certain thing. That's what that means. It says, as discussed above, the government Santiago Proffer lacked the necessary specificity, as to the statements themselves and failed to attribute the statements to their respective conspiracies. These shortcomings matter beyond the immediate application of Rule 801D2E. They also matter to the extent that they affect the court and the parties' ability to draft limiting instructions regarding the charges in this case. For instance, Mr. Brown cannot, by reference to the government's indeterminate and imprecise Santiago Proffer identify which statements are admissible for purposes of count 6. Okay. As noted previously, Mr. Brown is charged in only one count, count 6. Moreover, that count, despite incorporating language from count 5, charges only one conspiracy, an effort by Kelly, McDavid, and Brown, individual A, B, and others to receive child pornography. None of the incorporated language from count 5, paragraphs 1, 3, 4, 5, 6, 7, E, and 8 is necessary to a determination of Mr. Brown's guilt. Wait a minute, what she said? Okay, that was what she said it better than I said. So none of the incorporated language from count 5, paragraphs is necessary to a determination of Mr. Brown's guilt or innocence as to the charge alleged in count 6. Accordingly, Mr. Brown will seek limiting instructions as to evidence admitted against his co-defendants, including evidence admitted to prove the conspiracy alleged in count 5. Additionally, Mr. Brown may seek to strike the incorporated language from count 5 as surplusage as to Mr. Brown as count 6. Okay, so surplusage is means that it's something in the paperwork or something in there that's irrelevant. All right, that's something that's irrelevant, so it's not actually needed. So that's what that means. Let me see. What was I? Okay, so count 5 as surplusage as to Mr. Brown's and count 6. Alternatively, and as a last result, Mr. Brown will be required to move to sever, oh Lord, under Federal Rules of Criminal Procedure 14. Wow. So I guess, like I said earlier, at some point she's going to go back and try to get this severed again. Conclusion. In short, the government did not submit a sufficient Santiago proffer. In sum, the proffer that is submitted failed to provide the appropriate detail and specificity as to number one, the statements it seeks to admit, and number two, which statement goes to which conspiracy. As discussed above, the inadequacy produces three unacceptable results. One, it does not allow the court to evaluate the admissibility of the statements. Oh, okay, so she now is putting a little pressure on the judge. She's saying, hey, judge, you're going to be affected by this too, by this improper Santiago proffer. All right. And number two, it prevents opposing counsel from objecting to any particular statements. And number three, it unduly burdens opposing counsel in the drafting of proposed limiting instructions. And I told you what those are. And so for those reasons, Mr. Brown respectfully requests that the government order a amended Santiago proffer or deny the government's motion. So what I think is going to happen, and I'm sorry y'all for that choppy reading, child, but I'm tired as hell. But listen, so what I think, and this is just what I think that the government, will, I don't know. I don't know. Because when I was thinking right then, when we looked at that government's proffer, wasn't it pretty detailed? Wasn't let me look at it real quick. I'll let y'all go because I want to look at this real quick. I'm tired as hell. I can't even think, honey. Let me see. Milton. One thing about this mess, you always have to go back and refer to, some other document. Okay, let me pull this up. Okay, just 1 minute, y'all. I want to make sure. Okay. Provide statements here say upward. Okay. Thus, which does not detail the government's evidence that will go to show the existence of the charged conspiracies or all the conspiratorial statements that were made in furtherance of the charged conspiracies. Rather, the submission highlights for the court certain of the government's evidence sufficient to establish the existence of obstructions of justice conspiracy described in count 5 and the related receipt of child pornography conspiracy described in count 6 and the participation in conspirators. As a result, the submission does not list all of the government's evidence and witnesses, nor does it provide all the evidence that will be presented by identified and by witness. Oh, okay. So listen, the government may come back without any changes because it pretty much gave their reasoning why it may not have been specific per conspiracy. Because they're saying right here, as a result, the submission does not list all the government's evidence and witnesses, nor does it provide all the evidence that would be presented by identified witnesses. Okay, hold on. Overview of the charge obstruction. Let me look at this right here. Okay, it says the superseding indictment alleges that from approximately 1996 to 2001, Kelly engaged in sexual contact and sexual acts with minors, including minor 1, 3, 4, 5, and 6. As a part of this abuse, Kelly recorded himself engaging in sexually explicit conduct with minors on videotapes. During this time, approximately 1991 to 2014, Kelly, one of his Kelly businesses, employed Derek McDavid and Kelly's business manager as a business manager of Kelly's for the services McDavid provided to Kelly and for Kelly, and included protecting Kelly's image, reputation, and assets when victims of Kelly sexual abuse pursued or were a part of civil actions. Count 5 of superseding indictment charged Kelly and McDavid with conspiracy to obstruct justice relating to child exploitation and child pornography. If McDavid and others knew of Kelly sexual misconduct and minors and knew that Kelly recorded himself engaged in sex conduct on videotape. In approximately 2001, Kelly and McDavid learned that multiple such tapes were missing from Kelly's collection, including video 2, 3, and 4. After making this discovery, Kelly, McDavid, and others conspired to conceal and cover up evidence that included videos relating to Kelly's sexual contact and sexual acts with minors. Kelly, McDavid, and others also agreed to intimidate, threaten, and present other falsify and make up false entries in records and documents to relate to Kelly's sexual misconduct with minors. To accomplish this, among other things, Kelly and McDavid agreed to pay others to collect and return incriminating videotapes to keep silent about Kelly's sexual relationship with minors, one or more. Okay, so that is the obstruction of justice. Okay, all right, Kelly, sexual contact, Kelly, other incriminating videotapes, and to keep silent about Kelly's sexual relationship with minors, one or more. Further, Kelly and McDavid shall continue to conceal cover every sexual conduct with minors based on that account of conspiracy to. Okay, wait a minute. So I might have had that wrong. Hold on. Okay, so Kelly videotapes and other threat and other killers like that. Okay, wait a minute. So this obstruction of justice and the obstruction. Okay. Take that back. I told you wrong. All right. The two conspiracies is one the charge obstruction of justice. This is where is that the payment? No, the first one is the where they agreed to intimidate, threaten, and pressure others to falsify entries on in records and documents related to Kelly's sexual misconduct with others. Pay to collect. So, and they paid others to collect the tapes. That's the obstruction of justice conspiracy. The the um the the receipt of the child pornography conspiracy is the counsel's superseding indictment charges Kelly McDavid and Brown with conspiracy to receive child pornography. Brown, like David, provided services to Kelly for years. Counsel sir, Kelly's sexual conduct with minors, recording Kelly's sexual activities with minors when he discovered the videotapes. He paid others to recover the tapes, especially between the other individual. Huh? Wait a minute. Okay, that's paying. That's paying to get it back too. Why did they break it down like this? I'm sorry, y'all. Just give me 1 minute if y'all don't mind. If y'all don't mind, please type in if y'all don't mind, because I want to try to figure this out. Conduct with videotape during this time. Well, give that for the best manager. Give it that. Kelly include protecting because amateur protection assets of being a sexual abuse. Campus with the indictment related with conspiracy to obstruct justice relating to child exploitation and child pornography. Okay, conspiracy to obstruct justice relating to child exploitation and child pornography. Okay, that's what the first one is for. Okay, it's due to obstructing the justice relating to the child exploitation and the child pornography. The the receipt of child pornography conspiracy is for them paying to get the tapes back. Okay, so that is the two heads of this conspiracy. Okay, I'm sorry, y'all. I had to go find that out. Okay, so that's what it is. My bad, y'all. My bad. So that's the two conspiracy. That's what she's talking about. So, but here's the thing, right? When I read that, the government's evidence that they have with regards to conspiracy can actually be offered to prove both conspiracies. So now I kind of take that back. I don't know if the judge will grant her that, and I don't necessarily know if the government would have to make remedies to say, well, this evidence supports this conspiracy, break it down like that in a revised motion, as Mary Judge requested. They may come back and say that, hey, this evidence proof, speaks to both conspiracies, right? Because you got one that's talking about the child pornography and the exploitation and all of that, and then you have the recovery of them, the money they, that was allegedly paid to get it back. So yeah, I don't know how that's gonna turn out, y'all. I don't know about that. Let me speak to some more people. What's up, Leslie Jennings? What's up? Hey, LaBelle. Oh, thank you, LaBelle. LaBelle, I am rusty as hell, honey. I'm tired. I miss y'all too. Hey, Purple Purple. Hey, my Purple Purple. Yeah, but I miss y'all too. I'm telling you. I'm tired as hell. I don't know if I'm going to coming, honey. I really don't. I'm definitely not gonna hold y'all long. I got to get some sleep. I really got to get some sleep, honey. But I don't know if this motion would be successful for her. We love Miss Mary over here. We love Miss Mary, but I don't know if this is going to work out. I really don't. So I just wanted to come in and do. It wasn't really that much to talk about with regards to that, but as long as y'all understand what she's asking for, It should, when the prosecution respond, then it should be, hey, it should make more sense, right? Because what they're going to do is they're going to come back and either explain either why they didn't revise that Santiago Proffer, or explain, re-explain, break down what they already submitted, right? Which is going to be beneficial to us, because hey, we don't have the paperwork, we don't know what they're looking at, and we can only try to decipher from what they have. It's hard to do this when you don't have the case in front of you. It's hard to do this. You don't have the paperwork. You don't know what they're talking about. You don't know if the government does have something where they could better, where they can accommodate her. I did, when I read in there, I saw where she was saying like he they may have to sever at a later time. But remember, the judge ordered that there would be 3 separate panels for trying to get the juries up. And that means a separate jury for each of the defendants, right? And what that allows is just the evidence with regards to that defendant being presented. So we already know that there is a remedy already discussed as far as that. So again, I don't see a severance taking place. I don't want to say that, because he I mean, Milton Brown is only on count 6, and that would be totally, it could be prejudicial, very prejudicial to him if he stays connect, as a joiner, right? It would be extremely prejudicial because he just on one count, and you got McDavid and all up and through that. R. Kelly's situation. Yeah, I don't blame her for fighting for that. I really don't. But if they already got a remedy on deck, it's probably not gonna go through. So, hey Shorty, what's up, Karen J? Hey y'all. I'm about to let y'all have a beautiful weekend. I got to get up out of here, honey. Because that old choppy ass reading I just did, that's crazy. I'm glad y'all don't pay me, honey, because I would have to refund y'all damn money. Let me get the hell on up out of here. Make sure y'all hit those like buttons. And hey, thanks again to the host, the hostess, and the guests. And that's all of y'all. And everybody else. To the next live, honey. Make sure you love yourself, love somebody else, and do good for somebody else. I'm about to go. Lay it down. Miss y'all, love y'all. I'll be back. Bye.